I hereby open this academic ceremony, and I welcome everyone watching this public ceremony online. First and foremost, I welcome the PhD candidate today, Mr. Maximilian Vollmer, who will today defend his academic thesis entitled Financial Instruments and the Proportionality and Consistency under European Union Law. Mr. Vollmer defends his thesis before the committee here present that will decide upon the award of the degree. And I welcome all members of the committee, in particular the members coming from outside of Maastricht University, Professor Vedder and Professor Wisleet. And I also welcome the supervisors, Professors Nicolaides and Van den Brink. Mr. Vollmer, I now invite you to present a summary of your study and the conclusions of your thesis.
Thank you very much and good morning. I will now share my screen. I hope you can see it now.
Yeah.
Nice. Dear Prorector, dear members of the Corona, dear family, friends, and audience. In the coming 15 minutes, I will present shortly and introduce you to my dissertation, its findings and impact. I will start with the introduction, lay out the core definitions and assumptions, the relevant rules, and elaborate on the findings and the impact of the thesis. So the overall research question was, are financial instruments in secondary legislation and commission acts and guidelines inside and outside state aid law compliant with the principles of proportionality and consistency? So what are financial instruments? Financial instruments are member state or EU measures in the form of equity finance, loans, and guarantees to finance economic and political objectives. As such, financial instruments have certain peculiarities, especially vis-à-vis direct grants. They are implemented by a financial intermediary. They are set up at member state or at the EU level. They leverage private funding, and they entail different actors so that state aid can be present at different levels. And finally, they are repayable. So this research is very timely. It's very timely because we see an increased activity of the EU and the member states amid the Corona crisis. So we also see an increased use of financial instruments. It is also very timely because there is the fitness check and the review of state aid rules by the Commission until the end of 2021. And we have the highlighted importance of the proportionality principle, especially by the German Constitutional Court. And finally, we see no comprehensive research on financial instruments and their proportionality and consistency so far. As to the research methods, well, there was a lot of comparison. I compared the secondary legislation and Commission guidelines on the one hand. On the other, I compared Commission decisions, crucially with the case law of the EU courts. There was a comparison of state aid rules with the agreements for EU financial instruments. And these agreements are concluded between the EU Commission and the European Investment Fund, for instance, and hence are outside state aid law. And finally, I conducted expert interviews with open-ended questions. Which brings me to the very crucial principle of proportionality in EU law. It's laid down in Article 5(4) of the TEU, which reads that under the principle of proportionality, the content and form of union action shall not exceed what is necessary to achieve the objectives of the treaties. It is a very crucial principle, as I said. It forms the basis of the institution of law and of legal expectations. It manages legal expectations, and it serves thus the predictability and legal certainty, and hence very crucially, the very legitimacy of EU law. And it also limits EU and national law and balance different rights and principles. The principle of proportionality consists of four different steps. The measure in question must be appropriate to reach a legitimate, so we need a legitimate objective in the second step. In the third step, it must be the least restrictive measure among the appropriate measures, which is the so-called least restrictive means test. And the fourth step is the manifestly disproportionate test, which means the measure may not be manifestly disproportionate in terms of costs versus benefits. Especially under state aid law, the thesis also has shown that the EU courts put the emphasis on the fourth step, on the so-called stricto sensu or manifestly disproportionate test. It requires a balancing of the positive and negative effects of the aid, and the aim is to minimize market distortions. The second important principle of the thesis was the principle of consistency in EU law. It reads in Article 7 TFEU that the Union should ensure consistency between its policies and activities. Its aim is to tackle complexity and legitimacy gaps by eliminating overlaps, contradictions, and burdens, administrative burdens of the rules. It is thus also related to the principle of legal certainty. In this thesis, I used broad understanding. The broad understanding of consistency in this thesis was that we have either the absence of contradictions between the rules, as well as the making sense of the rules as a set. The core assumption behind it was that the less ambiguous the legal framework is, the clearer the rules, and the more efficient and less costly the use of financial instruments for stakeholders are. As to the relevant rules, the central legal basis is Article 107 of the TFEU. We have the 5 cumulative criteria which have to be met cumulatively so that state aid is present. If state aid is present, it may be so-called exempted under Article 21 GBR, which means that there need not be any notification or approval by the Commission if the financial instrument meets the criteria on risk finance under Article 21 GBR. If it is not compliant with the GBR, however, the financial instrument needs to be notified to the Commission and approved by the Commission under the conditions of the so-called risk finance guidelines. Other relevant rules for financial instruments are the Common Provisions Regulation on European Structural Funds, its Commission Delegated Regulation, the Financial Regulation on the General Budget of the EU, as well as the Minimis Regulation, which excludes aid, and the reference rate communication of the Commission for Loans, as well as the Commission Notice on Guarantees. As to the findings of the thesis, first, the thesis found that the definition of the concept of financial instruments inside and outside state aid law is inconsistent. We see an unclear definition of, on the one hand, financial instruments, and on the other hand, on the concept of risk finance aid. Related to that, state aid rules and the legal framework of financial instruments in and between the GBR, the CPR, and the financial regulation are inconsistent. So we see, for instance, that certain expiry dates contradict each other, and we see a piecemeal approach with different rules rather than a coherent set of rules. The third finding was that for financial instruments, it is very difficult to measure the aid element in order to exclude an advantage under the so-called market economy investor principle, which means if a public investor invests under the same conditions and circumstances as a private investor, an advantage may be excluded and hence also aid, which is, however, as the thesis has shown, very, very difficult in a risky environment that is very prone to risk asymmetries, to information asymmetries, sorry. However, at least we see that the approach by the Commission under the market economy investor principle is consistent with the requirements of the courts. Crucially, the proportionality principle and the findings of the thesis were that the Commission's compatibility assessment in its decisions is not consistent with the requirements of the courts. As I earlier said, the courts require a balancing of positive negative effects under the so-called manifest negative, under the manifestly disproportionate test. We see that it does not exercise this balancing approach, but rather uses a very formalistic approach by merely checklisting maximum amounts and market mechanisms in order to minimize market distortions thus. The same also applies for EU financial instruments outside state aid law. The EU agreements between the Commission on the one hand and the European Investment Fund on the other also rely on maximum amounts and market mechanisms in order to minimize market distortions. We do not see any balancing exercise or any predefined negative effects either. Thirdly, the thesis showed that there's an inherent principal agent problem between member state managing authorities, for instance, on the one hand, and financial intermediaries, mostly private ones on the other hand. Therefore, there are certain accountability mechanisms in state aid law and in the EU agreements on EU financial instruments. They are both very comparable, but they cannot ensure the minimization of market distortions. So in conclusion, what we see is that the Commission merely checklists maximum amounts and market mechanisms. It uses a very formalistic approach under the proportionality principle, which is not sufficient under the requirements of the courts. A solution to solve this impasse could be the introduction of manifest negative effects, which are predefined, pre-balanced negative effects that are also used in other areas of state aid law. So this could enhance consistency overall and legal certainty. So as to the impact of the research, the elimination of inconsistencies and the compliance with the proportionality requirements may in the end help achieve European policy goals and limit market distortions. A consistent and clearer regulation may help stakeholders, which are very plentiful, use and implement financial instruments more easily and widely. This was also shown in my interviews, which I conducted with policy experts. And finally, the increased certainty for member states could help make financial instruments compliant to begin with, so that member states are not forced to have them returned to the EU. So my research is very timely, and we see the recently published draft risk finance guidelines, which lend themselves for a comparison, for benchmarking with the findings of my thesis. I tried to do this in the following. On the plus side, we see more consistency within the text, which is a very good thing. We see more consolidation of the text, a reordering of the text, and also there's more guidance on certain concepts. For instance, how market failures need to be demonstrated. This is also in line with stakeholder questionnaires the EU Commission regularly conducts, or on behalf of the EU Commission, so to say. The focus now lays on the compatibility assessment, which the proportionality assessment is one part of it, which is actually the very central part of the risk finance guidelines. So this also avoids overlaps with other Commission texts. And we see finally the alignment of formulations and definitions with the GBA, which also increases overall consistency. On the negative side, however, there's still a mere checklisting of for the probability assessment. There's no proper balancing of negative and positive effects, and the manifest negative effects are, of course, also not to be found. Yeah, thank you very much for your attention. I give now the word back to the pro-rector. Thank you very much.
Thank you so much for your presentation. The opposition will be opened by Professor Snyder. Professor Snyder is Professor Emeritus of European Migration Law, and she is also the chair of the Assessment Committee. And I'm very happy to give her the floor.
Thank you very much, Pro-Rector. Dear candidate, I really would like to start with compliments. I think it is really interesting to read your thesis, also when I got the first and restarted now reading your impressive book. One compliment is already the very clear structure of the book, the very clear analysis, also this, I would call it wonderful boxes of case law, really very clearly put together. And I can also compliment perhaps the supervisors for that, because I think this gives a very good insight in, and also helped me enormously to reread when I received your book, to see the case law so clearly. So really all my compliments for this. And I think what you mentioned just now, that your topic is enormously timely. I think that is true. I mean, we had the COVID pandemic with a lot of financial measures taken, where also the issue is very much important, whether they were all proportionate, etc. So all my compliments to that. Now, coming to the start of the discussion of today, I really would like to start directly with the proportionality principle. And also, you referred now also in your introduction very clearly the main parts of the proportionality. You referred also to Article 5.4 of TEU. But if we go back to, let's say, the beginning of European law and the proportionality principle, it came in the case law of the court via the while the common market principles and the free movement rights. And here I have my question also in your criticism on the Commission, because if we would compare, because very often in the common market law or now in the internal market issues and citizenship, it is the Court of Justice gives the proportionality principle the final test, mostly back to the member state, because it's a preliminary ruling and the member state courts have to deal then with the balancing. And your criticism in the EU law with the Commission is that this is very often not done consistently. Now, if we would have a comparable research and looking at the member states courts, how they deal with proportionality in the various cases and looking at the different traditions of the member states concerning the proportionality principle, we also would see enormous inconsistency. And we can see that. Now, the question now is with your findings, because you say it should be much more, not the checklist, but a much more better balancing test. Would that really lead to more legal certainty? Is the checklist, to some extent, how the Commission uses it, not also a rather easy instrument in comparison to what you asked? Now, what has to do? It's different from the question what you also mentioned with the new draft guidelines, where you said the text have to be clarified on many points. There, I would fully agree with you. But what you ask now, especially with the negative test, is that really leading to more legal certainty for the parties involved, or might it even lead to more inconsistency in the long run? So that's my first question. And perhaps if you have some comments already on the relationship of, let's say, the Court of Justice and the Bundesverfassungsgericht in the Weiss case, I would be also very interested in this issue, whether the Bundesverfassungsgericht really kept its own proportionality test, which the Bundesverfassungsgericht originally has developed. But that's an additional issue. Thank you.
Yeah, thank you. Maybe I start actually with the additional issue, because my argumentation starts also from the angle of the German Constitutional Court. We see a highly critical Constitutional Court in Germany. We have this legacy for a long time, over decades now, the Solange judgments, more or less against the powers of the EU and the courts of the EU. So my concern is that we, amid these becoming highly active EU amid the Corona crisis, apparently the German Constitutional Court at least gets even more critical now. So I think it is very important, and I think the German Constitutional Court has a point if it says the effects, the policy and the economic effects must be taken into account under the proportionality principle. So if you merely use a checklist of certain criteria of maximum amounts and market mechanisms, helpful as they may be, they still do not take into account the very effects of EU policies. So, and especially under state aid law, where the Commission has this central role, the central function of controlling state aid so that market distortions do not happen, and that the EU internal market functions as well as it does. I think it is very important that the Commission and the EU take care of the proportionality principle. And so my argument is that as to legal consistency, of course, the Commission's approach as it works now is in itself maybe consistent, and I see where it comes from. It's under the aspect of efficiency and the tools it lacks to assess effects. But the EU Commission, as such a powerful and knowledgeable institution, is certainly able to predefine and pre-assess certain manifest negative effects, as it does in other areas of state aid law, which on the one hand meets the requirements of the courts, and thus hopefully also the requirements of the German Constitutional Court in the end, and other critical constitutional courts, and on the other hand also brings an enhanced certainty and enhanced consistency overall.
Would that not be enormously time consuming before you come to a decision of the Commission, Dan?
With regard to the manifest negative effects?
Yeah.
I guess so, but I see the manifest negative effects in other areas of state aid law, where you also have a lot of uncertainty when it comes to research and development, for instance. So I think the Commission could have a look also in these areas and apply them, adjust them to the realm of financial instruments.
Thank you.
The opposition will be continued by Professor Schoenmakers. Professor Schoenmakers is Professor of European Law at the Open University and also Associate Professor of European Law at our university, and she is a member of the Assessment Committee.
Dear candidates, I also want to congratulate you with your impressive dissertation. It is a topic that is very difficult. I think that we can certainly not forget that. It is really a challenging topic, but it is also of the utmost practical relevance, not only for the European Commission, but also for member states, for undertakings, and as you said yourself, for various stakeholders that are involved here. And what you wrote about the role and tasks of risk fund managers particularly intrigued me. Essentially, as I understood, risk management occurs when an investor or fund manager analyzes and attempts to quantify potential losses in an investment, such as moral hazard, and then that risk manager is going to take appropriate action or inaction, perhaps, given the fund's investment objectives and risk tolerance. So a risk fund manager has really an important and essential task, and many parties are really depending on the decision that this person makes. So my question or my questions are the following. Can you please elaborate a bit more on how risk fund managers are selected? So that is the first part. Then do you agree that the selection process eliminates advantage? And would your answer, that's the third part, remain the same in case such a fund manager also co-invests? I'm looking forward to your answer.
Yeah, thank you very much. Could you, sorry, highly esteemed opponent, could you please reiterate your second question?
Yes, so the first one is how are they selected? The second one is, do you agree that the selection process can eliminate advantage? And the third one is, would your answer be the same in case a fund manager also co-invests?
Thank you. So we see certain selection criteria for fund managers in state aid law, as well as under the EU agreements for EU financial instruments, which are very similar. For instance, they need a certain expertise, certain experience, for instance. So we have very specific selection criteria, which I also summarized under the term market mechanisms. So I do think that the selection process helps in a way to take away the advantage and to apply certain market conditions under this construct of financial instruments. But when we see the co-investment, and I elaborated on that principle, it becomes more difficult because fund managers or financial intermediaries, if they co-invest, it may become problematic because they have a certain contradictory aims, maybe, so to say. If they co-invest, of course, they want to generate profit. And if they generate profit, this may, and I also elaborated on that, may play into the into the concern of the principal agent problem, because it goes against, or it might go against, the profit seeking of the financial intermediary as a co-investor, might go against the very goals of the financial instruments. So if you have, for instance, a social goal of financial instruments, this may contradict the profit seeking of the fund manager. So this is, well, I think it enhances, and the interviews showed this as well. It enhances the skin in the game for the fund managers and their crucial roles. So they have to lose something. But on the other hand, this may go to the detriment of the very goals of the financial instrument. So in terms of, or to summarize, I do think it helps in minimizing the advantage, and it does help to a certain degree in minimizing market distortions in the end. But as such, it's as I explained earlier, in the overall concept of proportionality, for instance, it's not sufficient.
So would your solution then be that these risk fund managers would be, for example, not allowed to co-invest in the structures where they are playing an active role?
It's a very difficult question, and further research could go into the possibilities of accountability, actually. So how do you make them more accountable under the concept of co-investment? Yeah, very, very hard question. I do see definitely the positive sides of co-investment, but when it comes to the EU goals, they may suffer. So I can't give a clear answer to that. I think you would need more research on accountability mechanisms into that.
Thank you.
Now, the opposition will be continued by Professor Vedder. Professor Vedder is Professor of Economic Law at the University of Groningen, also a member of the Assessment Committee, and I would like to welcome very much Professor Vedder to Maastricht University today. You have the floor.
Thank you, Mr. Pro-Rector. Esteemed candidates, I can only reiterate the praise that has already been spoken about your very nice thesis. You tackled not just a complex topic, you tackled it in a very elegant way, in a very well-structured manner, which really helps the reader to understand this complex field. And in all of this complexity, I'm going to ask a really simple question. And the really simple question, well, actually, I'm going to make it a bit more complex again, also in view of the lovely discussion that you had before I got to ask my question. The simple question is really a methodological question. In chapter 6, you compare the court's assessment of proportionality using a number of landmark decisions with 3 recent commission decisions. And when you do that, the first thing that pops up in my mind is NS3. How can this be a reliable cross-section of the Commission's decision or practice? So how can you ensure that this is indeed a scientifically valid, reliable comparison? And to complicate this question a bit more, and also tapping into some of the issues that you've addressed in the earlier exchanges, shouldn't you also in this regard be taking into account the fact that there is a discrepancy between proportionality testing of a rule that has a general application and rules that have a specific application, i.e. the general rule laid down in, for example, GBER guidelines, etc., and the specific application in a case that involves a specific aid measure. You're referring to the efficiency of rules at a number of occasions, and I was also wondering whether this rule specificity should not also impact the assessment of the proportionality and thus efficiency impact. So my 2 questions: how can you have a valid comparison using just 3 commission decisions? Second question, how does the rule specificity, So are we looking at a rule that has general application or a rule that is confined to one specific instance, one specific case? How does that impact proportionality assessment and, as a result of that, efficiency of that outcome? I look forward to your answer.
So as to the first question, of course, I consulted various, like dozens of commission decisions, and I looked into them. All I had to do, of course, with financial instruments. But I picked 3 of them of all these to make it more concrete, of course, on the one hand, and on the other hand, those were very timely, very comprehensive decisions I selected. The selected decisions clearly show the different steps. You can find all of these formalistic steps, these checklists in the other decisions as well, but not as comprehensive as these. And also one of the cases had a very interesting insight into business angels, which may fall also under undertakings. So that was a very nice aspect as well. So to your second question, I'm not sure if I completely get it. Could you quickly elaborate on what you mean with general rules and specific rules, and so what your direction was?
Yeah, so you're right that the predictability, for example, I'm going to connect it slightly to my second question that had I in my second question that we have pre-discussed in the committee. Mm-hmm. So you connect predictability to efficiency, mm-hmm. and that makes sense on a general level. However, shouldn't you also factor in rule specificity, in the sense that when you have a rule that is intended to apply to a large, perhaps indefinite or indeterminate number of cases, the level of protection that you're trying to achieve with your rule also impacts the efficiency of the outcome. And given that the cases that you've studied were cases that dealt with individual state aid measures, shouldn't that also impact the assessment of the proportionality as you have conducted it? So to put it really simply, is it wrong for the Commission to go for a box-ticking exercise when the boxes have already been predefined in a general rule that says we're going to look at the following boxes because we believe that in general, ticking these boxes will separate the chaff from the wheat in, let's say, 90% of the cases. They may miss some chaff, they may miss some wheat in the remaining 10% of the cases, but we consider that to be acceptable, also in light of, well, the costs involved in administrating the system, the costs involved in member states having to wait for a finely reasoned, intricately reasoned decision.
I see. Yeah, I think I get it now. Yeah, we see an inherent problem between the specificity of rules and the piecemeal approach, if you will, on the one hand, and an ideal of efficiency and clear, coherent rules. Definitely, I think that has to do with, and that's what the interviews also confirmed. This has to do with that we have a very, very specific technical subject matter at hand, which is very changing by the day. We have innovations in this field, so I do get this aspect where the specificity comes from. But nonetheless, I do think if you put the very specific rules more like under a coherent set, as the Commission does in other fields of law, this would enhance legal certainty, although the specificity of certain rules, and maybe the adjustability may still be preserved. So yeah, I hope this answers your question in a way.
It does, yes. Thank you.
Thank you so much. Now the opposition will be continued by Professor Philipsen. Professor Philipsen is professor of shifts in private and public regulation at Erasmus University Rotterdam, and also an associate professor at our university. And he's also a member of the assessment committee. I'm going to give the floor to Professor Philipsen, but before I do so, I just want to ask the candidate also to address the opponent in the appropriate way. Yeah, thank you very much. Now I give the floor to Professor Philipsen.
Thank you, Mr. Pro-Rector. Dear candidate, dear Mr. Vollmer, congratulations on finishing your PhD manuscript, which indeed contains an in-depth and also critical legal assessment of state aid rules and case law on financial instruments from several different but connected perspectives. Like my colleagues before me, I enjoyed reading the book very much. Now, being the Law and Economics member of this assessment committee, I considered it my task now to ask you about one of the economic concepts that you've applied in the thesis. And it is a difficult choice because I had two options and we have been discussing efficiency a little bit. I'm not going to ask you the question about efficiency, but I want to briefly state a point on that. I mean, efficiency is of course related to consistency and to legal predictability. I very much agree with you, but if something is legally predictable but consistently wrong, it will not be efficient. So there's more to efficiency than that. But I'm not going to ask you this. We can maybe discuss it another time. My real question relates to your proposition number 7. So it's about the market failure concept. So I'm going to read this proposition briefly to everyone. So you write there, in accordance with the EU court's compatibility requirements, legislation, and the Commission's decisional practice on financial instruments and risk finance aid should rely on the broader concept of discrepancy between desirable and actual market outcomes, rather than on the narrow concept of market failure to justify market interventions. Now, I would like to challenge you on this concept of market failure. Is this really a narrow concept, as you claim in this proposition, or is it actually the interpretation of the Commission that is and has been narrow in relation to the assessment of financial instruments? I mean, you talk about discrepancy between desirable and actual market outcomes. That's right, that's what proportionality requires. But okay, it's clear what the actual market outcome is. We can at least try to measure it, but the desirable one, of course, well, there are two options. The desirable option could be related to efficiency, and that's exactly the market failure, right? If it's different from the economically desirable outcome, then it would be a market failure. So my point is actually, there's more to this than just information asymmetry, which you highlight throughout the thesis. It could be an externality, it could be much more than that, right? And if desirable would not be economic, but let's say an equity-related reason, something normative, an EU policy goal, we have this in state aid policy already since the balancing test, the state aid action plan, now the common assessment principles, we do have this, an objective, a European objective. Well, there also, of course, we already see that the Commission has defined lots of objectives other than the market failure. So basically my question is then twofold. Do you agree that the concept of market failure is not as narrow as you claim it is, that it's really the interpretation? And secondly, it's not even problematic if it would be narrow, because the Commission already uses these other let's say discrepancies between desirable and actual market outcomes in the form of these common European objectives, social cohesion, environmental aid, you know them all, right? So this is my question to you. I'm looking forward to your reply.
Thank you, highly esteemed opponent. So my argument or my criticism of the Commission goes in the direction that of course it is free to put its focus on the economic concept, which is market failure, especially under the concept of financial instruments, because mainly it's about market failures, financing gaps. But we see in a general perspective, we see, as you already also mentioned, the externalities which can also be taken into account under the maybe more political, more social concept of divergence of actual and desirable market outcomes. And I do assume that the Commission does narrow it down in that way also for the member states, which might be, especially now in these more interventionist times, might be more prone to apply broader concepts, social concepts, also the financing of the very important equity market, or the creation of certain startup environments. So I do think it does narrow it down in its policy. In the end, it's a policy question, of course, but policy translates into the legal realm. And if the Commission narrows it down in the legal realm, I do think it should be consistent with the overall legal framework and open it more towards externalities which are possible under the broader concept, as I understand it, of desirable and actual market outcomes, which are, of course, very in economic terms very hard to measure. Well, you have actual market outcomes, as you said, and it's also very difficult to assess what under counterfactual circumstances what desirable outcomes might be, but that's a political question, highly esteemed opponent.
Okay, I accept. You seem to recognize that the justification for the market interventions is maybe less important than you made it seem in that proposition. Or maybe I'm over enthusiastic now. But I accept this answer, Mr. Prorector.
Thank you so much. Then the opposition will be continued by Professor Wislate. Professor Wislate is professor and director at the European Policies Research Center of the School of Government and Public Policy of the University of Strathclyde, and also a member of the Assessment Committee. And I would like to welcome her very much to our university today. Professor, you have the floor.
Thank you very much indeed. And thank you, Mr. Vollmer. I'd like to add my congratulations, of course, for your thesis. It's a highly relevant topic, which is not well, both state aid and financial instruments are rarely tackled in PhD thesis. So it's an uncommon treat to have them both addressed in the one thesis. My main interests are in the kind of policy implications of your work, and you mention in the thesis, or one of your propositions is that the criterion of manifest negative effects should be used to assess the compatibility of member state financial instruments and EU level instruments. And my question is, how would this work in practice? You've been critical of the kind of mechanistic approach of the other criteria used. Isn't there a risk that you apply that you replace one mechanistic approach with another checklist? And in this context, isn't there a particular issue associated with this form of intervention financial instruments are essentially viewed as a market-based mechanism, where we know that the uptake and interest amongst firms in publicly backed instruments varies considerably over time, depending on what's happening in the commercial sector. So how would you address the kind of like the checklist problem? You know, replacing one checklist with another, and how would you deal with the kind of like the dynamic side of things where the assessment might change over time? Thank you very much.
Thank you very much, highly esteemed opponent. Well, as to the checklist problematic, excuse me. Well, my argument goes into direction that, of course, we have one checklist now, and there might be another checklist of these predefined negative effects, but I do think that these predefined negative effects, excuse me, predefined negative effects are in a sense pre-balanced, as I mentioned earlier. So I do think that the Commission does put up an economic analysis beforehand, bases these negative effects on economic grounds. And the difference is that, well, you now have a checklisting merely of certain maximum amounts, which might be also very, very vague or very made up in the worst case. Whereas with the manifest negative effects, you clearly see that these certain effects are highly highly disproportionate. I'm sorry.
No, please do take your time.
I hope it's fine now. Excuse me. So, as to the dynamic aspect, I highly esteemed opponent, could you please repeat your question for the second part?
Yes, of course. I suppose my question relates to, you know, one of the issues that you mentioned is the problem of predictability and legal certainty in the way that things are going to be assessed. And you know, we know from looking at the interest amongst final beneficiaries in relation to financial instruments that this fluctuates a lot. Sometimes they are interested in financial instruments, publicly backed financial instruments, and sometimes the EIB or other parties simply cannot, you know, get rid of the money. So the kind of like the market dynamics play a big role in that. So how would you reconcile the kind of like the certainty dimension with the you know the fact that the market is you know is always changing?
Yeah, I do think the market is changing. That's true. But we see that the overall trends go into the direction of a more financially active environment. We have the ecological issues which need to be tackled as an example. So, and also my interviews with stakeholders evidence that, for instance, the market economy investor principle is very popular among them. So if you base your financial instrument on the grounds of pari passu, so that an advantage is excluded and no aid present, this is highly popular amid these heightened uptake of financial instruments. And I do think this is a trend because financial instruments, in contrast to direct grants have certain advantages. You get private investors involved, you get their knowledge, you can base it on private-public partnerships. You can enhance through the repayability. You hopefully can also advance economic efficiency and make sure that the money really arrives where it should arrive and is spent with clear responsibility. So I do think the trend of financial instruments continues. It's a very good instrument vis-a-vis direct grants, but you also, of course, need to see the context in which one instrument against the other should be used.
Thank you very much. Thank you.
Thank you so much. Now, I first would like to ask Professor Wislade whether she would be willing to pose a second or follow-up question to the candidate.
Thank you very much. That's a little greedy, isn't it? As I've just been, but one of the things that you mention is, the large number of texts and the need for a better exchange between stakeholders and legislators. And I'm wondering if you could say something about at what stage in the policy process or decision-making process you would see that exchange taking place and what form it might take. Thank you.
Ali, esteemed opponent, you mean the exchange on which subject?
You mentioned in your conclusions, I think proposition 10, that an enhanced exchange between legislators and stakeholders would be beneficial. And given that there's already consultation over the text and so on, and a lot of guidelines, I'm wondering what more precisely what the role of the exchange would be between stakeholders and legislators there.
Mm-hmm. Well, I think it's an ongoing process. Of course, there's a lot of consultation, but when you look at studies by the European Parliament, for instance, on financial instrument stakeholders, they always say that you need more guidance. You need more guidance. Well, there is the new platform, which is called the FI Compass, which is, I guess, very helpful. Or that's what also the policy experts told me. It's very helpful. It delivers clearer guidance. You have best practice cases. But on the other hand, what is very, very problematic is that, especially at the communal level, at the urban level, where policymakers also want to implement financial instruments, they always say that it's too technical, it's too complex, too problematic. And that's also what the legal experts even said. So there's a knowledge gap. There's a gap of know-how, especially for lower levels of the political process. And as a result, we don't see an uptake of financial instruments there. So I think it is very important to have regular guidance, regular conferences on a national level as well as on a European level for policymakers to bridge this knowledge gap early on.
Thank you.
Yeah, thank you. Thank you so much. So I'm also assuming here that this does not, that it's a question I also have for Professor Wislade, that this may not lead to any follow-up question based on the answer that the candidate has just given.
I suppose there is an issue about reconciling the guidance and audit issues.
Thank you so much. Now, Mr. Vollmer, the time appointed for defending your thesis has passed. The degree committee will now withdraw to discuss the quality of your thesis and the quality of your defense. And I request that you and your company online will await the results of our deliberations and our return online in this room.
Go ahead.
Mr. Vollmer, the degree committee here present has assessed the quality of your thesis and the quality of your defense. In view of its positive verdict and taken into account your previous qualifications, the committee has decided to grant you the degree of doctor. Professor Van den Brink is authorized to confer upon you this academic distinction in accordance with Dutch university custom. And I now invite your supervisor to take the floor.
Dear candidates, do you promise to work in accordance with the principle of scientific integrity at all times, to be careful and honest, transparent, independent, and responsible?
Yes, I promise.
By the authority vested in us by law and in conformity with the decision of the committee, here present online, I hereby confer upon you, Maximilian Vollmer, the degree of doctor and grant you all rights attached by custom and law. As evidence of this, you will soon receive the degree certificate signed by the rector, the secretary, and the supervisor, affixed with the official seal of the university shown by the beadle.
And now I'm happy to give the floor to Professor Nicolaides.
Dr. Vollmer, dear Max, congratulations.
Thank you.
Your achievement today is the culmination of a long and arduous journey. We had our first contact about 5 years ago. At that time, you lived in Stuttgart and worked at the German Chamber of Commerce. Distance made consultations on your research a bit complicated. After the first few meetings in Maastricht, we had to rely on emails and Skype meetings. Of course, now Zoom meetings are the new norm, but not 3 or 4 years ago. So we were perhaps in that respect a little bit pioneers. Then things got even more complicated as Professor Van den Brink moved to the University of Amsterdam. Then not only did we have to find time that was convenient to all three of us, but also a suitable location for our meetings. Max, you are the only student with whom I had to discuss financial instruments in hotels and train stations. I'm sure you remember our meetings. Your achievement today is even more remarkable because halfway through your research, you changed jobs. You went from Stuttgart to Berlin to a position of more responsibility. You became head of the Department on Financial and Monetary Policy of the Economic Council of CDU. I have to confess that then I thought that that was the end. I will explain why. During the past 5 to 6 years, I have been asked by 8 persons to act as their supervisor. They were all young professionals in demanding jobs, but they also wanted to carry out research and pursue a PhD as external students. I said yes to all of them because they had brilliant ideas and seemed to be very motivated. But in all cases except yours, Max, it very quickly became impossible for them to combine a full-time job with study in evenings and weekends. Only for this reason, you deserve congratulations. But above all, you should be congratulated for the quality, depth, and originality of your research. Professor Van den Brink and I enjoyed reading your successive drafts and learning from your research. And indeed, this is what makes supervision such a unique experience. It is a joint learning process. And for that, Professor Van den Brink and I thank you. And I would like, and both of us would like, to wish you the best for your career. Now, I think both of us have a regret And the regret is that your research has ended. In fact, it's now that should be starting, given the fact that now there are so many new financial instruments on the market, especially the very unusual Pan-European Guarantee Fund, where member states receive money from the European Union, return the money to the European Investment Bank, and the European Investment Bank invests them on their behalf in their territories, and somehow these are subject to state aid rules which bind national authorities, not European authorities. So it's a very unusual hybrid procedure that indeed deserves research. Perhaps that will be the research carried out by somebody else. But anyway, on behalf of Professor van der Brink and all the other members of the committee, thank you very much and congratulations.
Thank you very much. Thank you. Thank you.
Now, dear Dr. Vollmer, you may have seen that your name, you may not have seen that, your name tag has changed already.
I noticed.
Also on behalf of the Board of Deans of this university and on behalf of the Faculty of Law, many congratulations on the degree that you have just acquired and also have very much earned for all the hard work that your supervisors just referred to. Also many congratulations to your supervisors. And Dr. Vollmer, the very nice thing I still would like to say is that you were not new to Maastricht. You did your bachelor's degree here with us at our faculty. And
True.
Good people always come back to do their PhD also at our faculty at university. So that's also very good to see. So many congratulations again, also to your family and friends. And with this, I officially end this academic ceremony.